Lawyers have read it. What is a detail that your client failed to bring up to you that completely lost you the case? He'd sent a photo of his wife's beaten face to his wife with a message saying something along the lines of this: "Do you want this to happen again?" He came across very well in court up to that point, but his mask slipped when that came out. Yeah, sounds like someone I know. He can keep the mask on for a while, but it starts to slip when his perceived world isn't reality. Shit. I took a picture of my ex who fell down the stairs twice in one night after drinking 4 bottles of wine and sent, "Do you want this to happen again?" In retrospect, that could have gotten me in some shit. A buddy of mine case as a public defender. A gal was busted on drug charges, and told him she didn't have any drugs on her when they arrested her. He thought, okay, we'll use that. Turns out, she didn't have any drugs on her when they arrested her because she just sold them to an undercover cop. Well, technically, just kidding. I do wonder though if she was actually smart enough to think of that on her own, or she was just being stupid. Well, I guess technically she was being stupid either way. Lol. The attorney likely wasn't all that bright either. Arrest report would show what she did to get arrested, so if they honestly didn't know she sold drugs to an undercover cop, then that's on them really. Honestly not sure how many of these stories are true. People are acting like the only information attorneys get is word of mouth from who they're defending. Absolutely could be true. You often have very little information from the state when you make bail hearings on day one of a case. The discovery obligations don't kick in yet, and the state is often getting a trickling of information through their police sources as the day goes on. It's quite common for them to have extra stuff by the time you make the argument. You also often have clients that provide pretty much nothing you can use for a defense to get them out of custody, but it's still vital that you say something because the clients with the least helpful stuff for you are often also the clients that are on the lightest hair trigger away from going ballistic on you and accusing you of trying to railroad them. When you know there's next to no chances you'll be able to get them out, you still make a pitch out of something, just to show them that you're trying. If it backfires, oh well, they were already going to stay in custody anyway. Little late to the party, but here goes, and obligatory. Not my client. Company I worked for at the time was doing due diligence before acquiring a small tech startup. The COO of the tech startup was a well-liked guy in the company, friendly and outgoing. Though we had heard rumblings that the COO was rather hands-on with the work and with female employees. Apparently there was a walk-away package proposed to the COO that would let him keep a sizable portion of his post-acquisition bonus because a young woman who worked in their sales department had filed HR complaints against the COO and obtained counsel. I sat in on the meeting with the COO and the company's retained lawyers while they grilled him about his contacts with the young woman. The COO denied ever having contact with her within the company without multiple other people present. Those people said his behavior toward her in the meetings didn't raise any flags. The COO emphatically denied having any contact with her outside of work. The lawyers asked the question a half dozen different ways and each time the COO denied any out-of-work contact. Later we meet with the woman and her lawyer with the COO not present. Her lawyer gives us a rather graphic card that came with a bouquet of flowers addressed to her from the COO. The guy had an account with a florist linked to his credit card. When the company retained lawyers confronted him, he said, "But I never had contact with her. It's not like I delivered the flowers myself." COO got terminated for cause, so no walk-away package. At her request the woman was given PTO until after the acquisition, then moved to another one of the companies under our umbrella. Custody case. Client failed to tell me he was previously convicted of felony child abuse for breaking 16 bones in an infant's body. I know that there's the whole everyone has a right to a fair trial and good defense thing, but holy shit. Have you ever had a client where you knew from the beginning that they did something like that, and if so, how did you feel defending them? I have to imagine this would take a serious toll on you. I can compartmentalize with the best of them, but I don't know if I could with something like this. My house was robbed. In addition to all the stuff the thief took, he also stole a bunch of my suits and all of my neckties. I had a big collection, like 100 or so. However, the thief left fingerprints on a hard plastic box that I kept spare change in. Fast forward 3 months, the thief is caught in the act of robbing another house in the same neighborhood. Same detectives on my case in this new theft. They fingerprint the guy and the fingerprints match the ones from my house. At the thief's arraignment, I see him stroll in wearing my suit and my tie. I tell the district attorney, he says there's really no way to prove it. However, The tie he chose to wear was a one-of-kind street map of San Francisco, and I still had all the documentation to prove it. The district attorney's eyes widen and he informs the judge. The judge has the thief placed under arrest again for possession of stolen property. The thief's lawyer was dumbfounded. It was a nice end to a rough situation. I hate that this happened to you, but I love this story, LOL. Amazing sidebar to the story: every year my wife's grandmother gave her a pearl for her birthday, Christmas, and other special occasions. By the time we were married, my wife had an entire necklace. After the theft, the necklace was gone. Her grandmother had passed, so it was all we really cared about. The rest of it was just stuff. We move out 4 years later. I move her dresser and hear something hit the floor. It was the pearl necklace. Somehow it had fallen behind the dresser before the robbery or during it, who knows. Bringing it to my wife was one of the best feelings I've ever experienced. Lawyer in the UK. I acted for a member of a famous pedophile hunting group. My client was charged with various offenses relating to his vigilantism, most seriously, causing grievous bodily harm with intent. He wanted me to fight the case on a public interest defense point that is not available to him in statute or at common law, contrary to my advice. I followed his instructions, as I'm bound to do. If the state won't punish pedophiles properly, then it's left to men like my client to take the law into their own hands, a horseshit argument for a whole host of reasons. His laptop was seized by police and submitted for forensic examination. He had a staggeringly huge database of child pornography on it. He himself was a massive pedophile. I beat up pedophiles in my spare time. No one will suspect a thing. That he filmed his offenses for his YouTube channel. The cops didn't even know. A witness brought it up on day 3 of a trial. It was a nice quick change of plea that afternoon. So you're saying, it's just a prank, bro? Isn't a valid legal defense? Not since Prankster vs. Bro, in 1986. Case as a paralegal. Negligence case. Client argued that a lack of streetlights and a cyclist he couldn't see was responsible for him hitting a wire pole. Upon discovery, the first respondent's report indicated that they found the driver in the driver's seat, pants down, with porn playing on the phone. Wasn't difficult to figure out who was negligent at that point. Your Honor, if the cable repairman had simply fixed the cable in accordance with professional standard practices, my client would have had no other recourse but to keep his ostrich in the corral on the evening in question. Guy in prison hired me to request a modification of his sentence because he was doing very well, completing a lot of optional programs, no rule violations, etc. He had his family come in and pay and everything to get started. I asked the family and the client if he had requested modification before, because the law said that for his conviction, he could only request modification twice for any one sentence, regardless of if they were granted or denied. Swore up and down he'd never filed before. You can see where this is going. After spending a few hours going over records and preparing documents, a copy of the CCS, the case record basically, finally arrived. He'd personally filed for modification 6 times since he was sentenced, with handwritten pleadings that were all denied. So the one he hired me for was a waste of time and would never be considered at all. What was he in for? If he was telling the truth that he was completing all of those programs and not getting written up for anything, was there something to do with the severity of his crime that made the courts reticent to grant his request? Several counts of burglary and armed robbery. The statute gives him 2 chances to request modification during his sentence, and he used those up and then some very early in his incarceration before he'd completed any programs. I'm talking multiple requests in the first year. At that point he hadn't done anything to show he was rehabilitated, he just wanted to court to reconsider his sentence, which is not the point of the modification statute. It wasn't about the severity of the crime, it was a procedural issue. The limit keeps inmates from bombarding the court with constant requests like his and allows the courts to just automatically reject excessive requests. So it had nothing to do with the merits, he had just screwed up by not consulting a lawyer before filing a bunch of requests. And then lying to me, causing me to do work on a matter that had no chance of accomplishing anything. I'm a court-appointed attorney for qualifying individuals in family matters. Termination of parental rights case. Have been fighting to argue that parent is stable, working lawfully, has a suitable apartment, doesn't need psychotropic meds anymore, ready to be a parent, etc. After a few months of negotiating with all the parties and Department of Children, Court Services, we have a pre-trial to try and convince guardians. I meet with my client before the hearing to see if anything changed. Nope, all good, let's get my kids. Great, that's not happening today, but let's try. We get going in court. My client, who is super hot-headed and quick to anger, gets riled up and goes off on the guardians, screaming in open court. It doesn't end there, but reveals 1. That no longer is working, 2. No longer in apartment, 3. Doesn't want to have a relationship with guardians despite her kids loving them, 4. Won't send her kids pictures of the toys they miss and can't have, 5. Plans on moving out of state, 6. Thinks they can live as a family off of state aid when she gets them back, and is 4 months pregnant. All in the matter of 15 seconds, I was too shocked to even react. Speechless. Not the image of stability and parental fitness I've been trying to paint since last July. We became a foster family about a year ago. We've had several short-term placements since then, and I always go to the hearings because that's when you can truly find out what's going on. Kid is put into care with all kinds of injuries that parent can't explain, but they all seem to happen when they're at work and the kid is left at home with family. It was very clear that the kiddo was being abused and neglected during these times, and their romantic partner was the only one there when these injuries were happening. Parent comes to court and lets us know that they've broken up with that person and we can give them their kid back now. Judge asks when they broke up and parent replies, "Just now before we walked in so I can get my kid back." Abusive person sitting next to them, drove them there, still living together, etc. Judge wasn't buying it. If you enjoyed this video, please like, share and subscribe. Let me know if you have any funny court stories in the comments. If you have any topics you want me to make videos about, please let me know. Thank you so much for watching.